G'day everyone, my name's Arjay Martin and this is Arjay's TINLA episode 158. TINLA is short for This Is Not Legal Advice and Nor Is It. So the reason why I've put this video together is basically I'm asking, begging, whatever you want to call it, for your help. So just a little bit of a background. So basically for many years, more than 10 years, I've been going around helping people with various problems, whether it be the Cameron Park roundabout in Lake Macquarie, where there was more than one car crash per day, and there was supposed to be a roundabout built there many years ago, and it wasn't built, despite it fulfilling the requirements and the developer doing developer contributions for it, etc. So I got that eventually built, although, traffic lights may well have been better, especially if across the road they opened up the next plot of land for housing development, but that's another story. Also, I didn't design that particular roundabout, nor any, but it is a terrible design where it's hard to see over the top of it, but you get the idea. And then later on in life, when No Jab No Pay came out, I contacted certain organisations with information, particularly about Section 51, subsection 23A of the Constitution, which allows for the government, and it applies to all levels of government, but allows them to provide medical and dental services so long as it does not constitute civil conscription, i.e. medical coercion. There's various case law about that from many decades ago, from the 1940s as an example, and basically I provided that information to a particular organisation that supposedly was going to do something about it, but never did, in terms of having a court case, that kind of thing. So basically, other people may know me from when I became the first person in Australia to protest the unlawful, ineffective, dangerous COVID restrictions, COVID directions, which, as an example, of them not working, you have the likes of Professor Israel and world-leading epidemiologist that compared basically the jurisdictions, the areas, countries, states, etc., that have COVID directions and lockdowns, very harsh COVID directions, and those that don't, and found that they had exactly the same pattern of infection, etc. You also have various professors and other experts in probably law, economics, health, etc., that basically show that not only do the lockdowns not work, they're not effective at controlling coronavirus, but they are very damaging to economies. You have massive increases of suicide, family breakups, divorce, joblessness, etc. And there are ways to try and cover those things up, like if you lost so many full-time jobs in a place and you just employ a bunch of casual workers, and then you can say, hey, look, there's still as many people employed now as there were before, as an example, but it's a false equivalence. So anyway, I started those protests on the 6th and 7th of April last year, that's 2020, and the first one was in basically my backyard, and then the day after I went to a park and started doing it from there, so that people would see that if I did get arrested or whatever, then they'd know that that's all that would happen to them. If I didn't get arrested, then it could embolden people to also stand up for their rights. Anyway, so I also had a number of court cases involving, our human rights, and basically they involved things like the right to protest, the lawfulness of the COVID directions, etc. And unfortunately, some of that took a turn. I'll just have to probably move the camera in a second. I'll just turn around the other direction. Sorry about that, there's just someone in the background with a torch of all things. Anyway, so basically with the various court cases, many of you know about, the main ones, which were, I believe, the first COVID-related court cases in Australia, and that is, concerning our rights, etc. And I did listen to various legal professionals, barristers, solicitors, as well as other people with legal qualifications that aren't practicing lawyers. And there were, conflicting ideas presented and conflicting information. It was only on an informal basis due to impecuniosity, or, basically I'm poor, so I couldn't afford to engage solicitors. I do have a Juris Doctorate law degree, but basically within a law degree, at least the one I studied, they don't focus so much on procedural law, but substantive law. So in other words, I'm pretty good with knowing what's right and wrong, but the procedures and the technicalities of running a court case, etc., is a different story. And even qualified solicitors, they get barristers to run court cases because barristers are experts in terms of procedural law. So basically, with those particular court cases, I tried exercising our rights via an appeal, or via two lots of appeals, so there were two separate threads, and then ultimately the court said that it couldn't be done that way, that it has to be done via a fresh claim and statement of claim, i.e. a new court case, instead of trying to add parties and add causes of action to appeals. Whereas in the magistrates court, where those particular cases stemmed from, where, well, really, I can skip over, or may as well just say it, I was unlawfully prevented by police from having protests and exercising our rights, then, I wasn't even allowed to speak more than a couple of words in the first case, and there was no jurisdiction for the court because there was no legally required mediation under the Peaceful Assembly Act 1992 Queensland, and therefore the court didn't even have the power to do what they did. And then also that particular police officer claimed in legal documents that there was a legally required mediation, so make of that what you will. But then basically the court said it doesn't matter what happens, this is very paraphrased of course, but it doesn't matter what happens in the magistrates court for peaceful assemblies in Queensland, that there is no possible right to appeal. So literally the judge could, discriminate against someone openly about protected, things like disabilities, or if they, if the judge was openly racist or something like that, and it doesn't matter. There's no way possibly to appeal it. So anyway, that does have an asterisk too, as does everything in law, whereas some people say you can do judicial review, which you can't really, because a judge making a judicial decision should not allow for judicial review, although there is a particular court case where that happened, and that's very peculiar, and it was even brought up, it's even in a judgment where people are saying there is no jurisdiction to do it as a judicial review because it's not an administrative decision, it's a judicial decision, but then that was just ignored. And that is the case of, I think it's called Brodsky and others, which is also called the Oakey Creek case. So anyway, I think Brodsky and others is the same one from the top of my head, but you get the idea. So I lost the appeal. I have very large costs awarded against me for trying to do it via an appeal, even though the court themselves didn't say that, there was no grounds or whatever in law for my arguments, in terms of, it's not law in Queensland, as an example, let alone Australia, but, it was dropped on its head due to technicality. So anyway, with that particular series of court cases, Crown Law has provided me with their costs, and if I don't pay X dollars by this coming Friday, then basically, which is the 9th of July from the top of my head, then I'll have to pay another roughly $7,000 to $8,000 on top of that. Then I have the QPS legal, Queensland Police Service legal costs, and costs from other cases as well. So I have included that information in the GoFundMe, as well as other information on, the unconstitutionality of COVID directions and what's been happening. And of course, as I keep bringing up, Section 47 of the Statutory Instruments Act, which says that for the COVID directions, this is applying it. So COVID directions are exempted subordinate legislation, but with those directions, then they are not law, they are not enforceable until they have been gazetted, and they were not gazetted, so, it's not law. Anyway, there's also another particular court case where I have stood up and was exercising my rights and our rights, that involves politics and people allegedly engaging in very unlawful means to conduct political campaigns to basically destroy my political party so that they don't have competition, basically, after I was previously asked by that particular political party to be one of their candidates, and I turned them down. So anyway, with that particular case, again, I have substantive law knowledge, but not so skilled in procedural law, so the pleadings weren't set out exactly how the judge wanted them and how they normally arrive. I, in good faith, used the UCPR, Uniform Civil Procedure Rules, 1999, Queensland, and, I guess someone could say took it too literally, e.g. where it says that you are to not provide evidence within the pleadings, as an example. So, that turns out does not mean that you don't say exactly what was said. But anyway, so I also pointed out what I allege is unlawful behaviour on the part of the other parties or their law firm, and then unfortunately, the judge took that as me being combative and awarded indemnity costs against me, which are like super costs. So normally, if you get costs awarded against you, it's about 60 to 70% of the so-called true costs or of the indemnity costs, and if you get indemnity costs against you, then it's obviously a lot more. So 1.5 times more, approximately. Anyway, that is on appeal, but again, I am lacking in procedural law and technicalities, so I need to get lawyers for that, and the next hearing for that is on, I think, the 13th of July or the 14th, one of those two dates. I'm pretty sure it's the 13th, and the 14th is another matter. And anyway, so I need to get money for lawyers for that as well, proper legal representation. And basically I'm asking for your help. One, because obviously I can't afford it. Two, the outcome is vastly different if someone's representing themselves. And three, basically, otherwise it'll bankrupt me. I won't be able to run for Parliament. I won't be able to be elected. I won't be able to be involved in politics anymore in terms of anything to do with political parties. I won't be able to eventually practice law because you can't do those things when you're bankrupt. And anyway, obviously that is not a good situation to be in. For all the costs and disbursements, etc., for various court cases, there are other ones as well, which again, is about standing up for people's rights, including my own. Then it's literally in the hundreds of thousands of dollars. So I have put for GoFundMe as the goal $350,000, and hopefully you can share the burden, so to speak, and indemnify me in a way for these costs. And that's not even the whole of the costs, and I've already expended basically all of my money that I can. I've already tried getting credit cards, etc., and unfortunately at this stage have been unsuccessful with that. And I don't have lots of valuables to sell or anything like that, and that's why I'm asking for your help. So please click the link, go to the GoFundMe, please share it if you can, donate or not. At least, if you can't donate but you appreciate me trying to stand up for your rights and my rights and everyone's rights, then please at least share it, because the more people that see the message, get the message, then basically the more people will know about it, and more people can donate, the more people can spread the word of what I believe is an atrocious tragedy. And there's not much more I can say about it. Okay, well, thank you. Please be generous and considerate, and if it means nothing else, you'll be very special to me. Thank you.